Good morning, good afternoon to my colleagues across Indian country. We have quite the treat in store for you today. Joining us for a discussion on negotiating rights of way on tribal lands is Margaret Schaff of Margaret Schaff and Associates. She's an attorney there out of Boulder, Colorado. She has more than 30 years of experience in areas of tribal legal codes, utility negotiations, electric power and transmission contracting, oil and gas, tribal energy resource development, and rights of way. Bit of a mouthful for me this morning. But we're certainly honored to have her present. I've taken a look at this presentation, and you really are in for a treat. So as usual, I have a couple just rules or some guidelines, if you will, about today's session. If you have any questions or comments, please use the chat feature. We save that chat log and we share it with our presenters. So that way, if there are any questions or comments that they can't get to during this session, they could follow up and we could attach it to the video recordings, or they could follow up directly if that's what the presenter prefers to do. But we really want to make sure that everyone has a chance to go through the information, and because it is such an important piece in Indian country, we want to make sure that we can do that in a meaningful way. This is recorded. I say this every time, but I want everyone to know, and you could share with your colleagues, that this will be disseminated to your colleagues and others after completion. So probably early next week, we're going to be looking at seeing this on our the ILTF Vimeo account. You will get an email about that, along with the evaluation link. And one final piece, it's more of an announcement. We've heard you, land staffers. I interact with you through this feature. I interact with you after the conference, during conferences. We have conversations throughout the year. You said that you'd like a venue, a space where you can communicate with other land staffers and professionals about topics relevant to your jobs. And so that's what we're going to do. On September 8th at noon Central, we're going to launch the first talk shop with tribal land staff. This program is designed to bring land staffers from across Indian country to Zoom and to network about topics relevant to your jobs. The link to register for this is in the chat box here. So I do encourage you, now or later, if you want to attend that on Wednesday, September 8th, to register. Again, this is really directed for our land staffers and our professionals out there who are looking to communicate with others across Indian country, to learn from them, to have fellowship, and to enjoy that company and that camaraderie. So if interested, take a look, register. We're going to have 3 sessions this year. This one coming up on September 8th about rights of way. So we're going to follow up with some of the information. If you have any specific questions, we'll talk to other land staff and have a better sense of hopefully what you can do with that. In October and in November, we're going to have sessions on FEDA Trust, following up on the webinars in the next 2 months about FEDA Trust issues and processes. So stay tuned. You'll receive emails about all this as well. But if interested, please do take a look at that registration link that has been submitted in the chat room. So without further ado, I'm going to pass on our time to our guest of honor, Miss Margaret Schaff.
Well, hi, everyone. Can you hear me okay? I guess I'm good to go, huh, Nichlas? All right. Okay, well, everyone, thank you so much for joining us today. I'm looking forward to this session. I've been working on right-of-way issues for many years. I started my legal career with the Western Area Power Administration as a land specialist, or real property specialist, working on transmission line rights of way and a lot of other federal lands. So I have the opportunity to work with many different tribes that were negotiating rights of way with the Western Area Power Administration years ago. And that's how I got my start in Indian country, is working with those tribal leaders. So I've been working in Indian country for about 30 years now. I've been practicing law for almost 35. I really enjoy my practice. I'm coming to you from Boulder, Colorado, where it's currently nice and pretty and sunny, although quite smoky from the fires in the west. So for those of you in California, you're present with me here in my air quality. Anyway, let me go ahead and share my screen, and I'll get going on this presentation. First of all, there's a picture of Yellowstone. You got some buffalo there in the background, and that's kind of what we're here protecting, is our lands. See, I'm trying to get this thing to do a slideshow for me.
I think in the lower right-hand corner, there's that little box with a stick.
Box with a stick.
Over to the left there. Yeah, right next to the minus sign.
Oh, this thing?
Yeah.
All right, thank you. Okay, I wanted to let you all know that this presentation was kind of designed not as a deep dive into the regulations. We do have new right-of-way regulations that came out in 2015 and were made effective in 2016. And for those of you that are professionals and deal with this every day, you're probably quite familiar with looking things up in those regulations. They're posted at 25 CFR 169. And I will briefly kind of go through those in context, but this presentation is really more designed to give you some historical background and to give you some ideas for best practices and other types of hopefully helpful strategies that you can work with as you're working on rights of way. And I wanted to talk today a little bit, not just about negotiating new rights of ways or renewals, but also just a little bit more about the current events, then also the historical context, because many of the existing Indian right of ways were granted under previous laws and sometimes as much as 150 years ago. And so those rights of way are sometimes still in effect. So you have to understand where those rights of way came from, as well as any new rights of ways that are happening. So we're going to talk again then about right of way management. So even if you don't have any rights of ways up for renewal, or if you expect to have rights of way up for renewal in the next 5 years or something, you can start getting ready by managing the existing rights of ways and getting your tribal codes and other things in place, so you're ready for these rights of ways. Next, we're going to talk then about the negotiation of the new rights of ways and renewals, and that'll include just an overview of the applicable law and regulations, how to do valuations, and then different rights of way language, kind of best practices. Then we'll have a Q&A at the end based on what I guess Nichlas gathers for me in the chat box. And I think I'm going to stop my video so that if I need to take a sip of water or something, you guys don't have to watch me. All right, so a little bit about current events. Currently, tribes and industry are both dealing with many expired and soon to expire rights of ways on Indian lands or lands affecting Indian country. And the lands affecting Indian country is really important because oftentimes there are going to be facilities on lands that are ceded lands or lands for which tribes have treaty rights. And you have to pay attention to those too. And you're not necessarily going to get any kind of notice for those matters. It may be consistent with like the XL pipeline that things just progress without the tribe having much participation. So you kind of have to pay attention to these lands, pay attention to your state siting agencies and so forth to make sure that if something is going to affect your rights off of your Indian lands, that you're paying attention to those. I'll skip to the last of my current event bullets here, is that the infrastructure legislation that's going through Congress right now will probably spur many new facilities and upgrades to existing facilities. So I think we're going to have a lot of new interest in rights of ways, both on Indian lands and off Indian lands, that may affect Indian rights or air quality or whatever. The next bullet here is that the allottees are also, of course, negotiating rights of way. And the rules are somewhat different for the allottees, so we have to keep those guys in mind too. Again, the new federal right-of-way rule was effective in 2016. And I think people are still kind of getting used to the new rules. There's a lot of really interesting new provisions there that I think are going to be helpful for tribes. And then right-of-ways are always opportunities for exercise of tribal sovereignty. And so really that's what this whole presentation is about, is making sure tribes can exercise their sovereignty through this type of land right. So next we'll talk about a brief history of tribal land rights, going all the way from before contact to the current time. So these are kind of the 4 time periods we'll deal with. The pre-Columbian and Columbian international laws, European expansion and European Christian international law. Then, of course, North America, pre-Columbian period to the US Constitution, the treaty period, and then allotment, reorganization, termination, and self-determination. So I promise I won't make this too long and drawn out, but just some kind of interesting history is that even before the year 1000, the actual land rights ruling body in the world was the Roman Catholic Church. And they established the idea of a worldwide papal jurisdiction and a universal Christian commonwealth. So in the 1400s, when maritime technology allowed for greater range of travel, they evolved this law into what they called the doctrine of discovery. So there are numerous papal bulls, which are basically papal laws, which divided the lands among discoverers. And the discovery of the mouth of any river on any, of course, it's not a real discovery. It's discovery for them, but not for the people that were already here. It gave the discovering government all the rights of discovery to the lands drained by that river. So the right of discovery included the exclusive right to buy lands from all the infidels, that would be us, thereon, that the natives continued to possess the lands until this happened. So that led to things like the map you see there. So for example, when the Spanish and then the French, quote, discovered the mouth of the Mississippi River, first the Spanish owned the Louisiana Territory, and then that was transferred at some point to the French. And then of course, after President Jefferson bought it from the French government, and the whole Lewis and Clark experience went through and helped understand what actually the US had bought. But different countries owned the discovery rights on different river systems. And the new United States obtained the discovery rights for the 13 colonies, and then continued to make sales agreements and began making treaties with the many tribes to obtain the land rights still possessed by those tribes in those different areas. Then, of course, led to the treaty period during the late 1700s through the 1800s. So it's kind of a misconception that the United States gave Indians the right to do anything. Treaties are actually grants of right from the Indians, which reserve all the rights that were not granted. So the treaties must be construed as the tribes understood them, and ambiguities are construed in favor of the Indians. And that's current Supreme Court law even today. So treaties place the word of the federal government behind the recognition of tribal sovereignty. And tribes that were not, or treaties that were not ratified by Congress don't necessarily have the same force of law, even though the tribes often continued to apply the treaties even if Congress did not ratify them. So during the later part of the treaty period came, of course, the removal period, where many tribes were traded, often by force, their lands in the east for lands in the west, and often individuals were given acreage rather than a communal tribal acreage. Congress ended the treaty making with Indian tribes after the Civil War in 1871. And to this day, Congress can abrogate your treaties, but they must do so explicitly in law. So before 1871, as it affects rights of way across Indian lands were all obtained through what they called negotiations that were ratified one by acts of Congress. So some treaties actually predate the United States. For example, tribes that were previously under Spanish rule in the West had treaties with Spain, and the Spanish land grants were to be honored under the US rule. So many of the right-of-ways you'll find today are actually some that were negotiated with the country of Spain, and some are actually subject to specific congressional laws prior to 1871. So it's really important when you're looking at a right-of-way on the ground. And some of these, for example, are the railroad rights-of-ways. They have particular laws that govern that specific right-of-way. So you have to understand what the rights and obligations are under those particular laws. Then during the allotment period from 1887 and after the General Allotment Act, this led to the general statutes passed during the allowing the Department of Interior to grant right-of-ways without the consent of tribes. That was until 1948. So you'll find railroads, highways, telecom, oil and gas pipelines, electric power and communications, hydro dams and transmission sometimes all have separate statutes that apply to them if they were before 1948. So there were three major types of land on reservations. We all probably know this, but I'll go through it quickly. Reservation, trust, and fee lands. So these are tribal trust lands, are federal lands. They're held in the name of the United States in trust for the tribe. There's no federal authority that exists to condemn tribal lands unless there's federal authority of general applicability that approves a federal action and clearly overrides an applicable treaty. Tribal trust lands may not be condemned by a state for public purposes. Regarding the allotted lands, the second type of lands, condemnation is allowed for allotments, and cases are brought in federal court under condemnations, and the United States is an indispensable party because allotments are held in trust by the United States for the benefit of the allottees. The last type of land on a reservation is a non-Indian fee-owned land, and these are subject to both federal and state jurisdiction, and to tribal jurisdiction, I'll say as well. So after the allotment, we had in 1948 a comprehensive right-of-way law, which you can find at 25 USC 323 and 320 to 328, and I'll kind of go through that in detail here in another slide. Some highlights include that tribal consent is required and fair market value is required. And then of course we have the BIA regulations that apply that describe that law. Just something interesting, the other day I was asked by someone, what's the difference between a law and a regulation? And a law is something passed by Congress, and a regulation is something created by a federal agency. And usually the laws, and this one is no different, the laws set up a framework for how the government is supposed to deal with a matter, and then regulations, which can be more easily changed through a process, an administrative process that involves publishing draft regulations in the Federal Register, allowing for comments, and then publishing a proposed final rule, and then allowing additional comments, and then publishing a final rule. So there's a whole set of process to create regulations, and those ones, the right-of-way regulations were completely redone in 2012 to 2015. Next, I want to talk about right-of-way management. So these are just, all of the different activities that are kind of best practices to manage the land rights that you currently have on your reservation, whether or not there's something new happening. If you have right-of-ways on your reservation, consider them an opportunity to exercise your sovereignty, and potentially to make sure that you're communicating with the partners that you have that are there on your lands, and to make sure that the tribe is being appropriately compensated for any land uses. So I think I have slides for most of these best practices, but I'll give you the summary. And that little picture there is really just kind of a generic picture of a spreadsheet. And so the first kind of the second bullet point there that I have is designate tribal personnel for right-of-way management. And one of the things that's really helpful to have is a little spreadsheet that shows what all of your different right-of-ways are. Start with your railroads, then with your water pipelines, with your sewers, with your electric, with your telecommunications, and with all the other kinds of rights of way, including roads and all other, even conservation easements. The new rules even allow for airport protection easements. So all the different kinds of easements, make sure you know under what law they were granted, when they were granted, when they expire, and specific terms and conditions, whether you have allottees and so forth that are also impacted by the same facilities. So the tribal personnel for these general right-of-way management can then have a nice tool for checking out any kind of particular issues and keeping track of particular issues. So the next really important thing is for the tribe to clarify its goals related to infrastructure. So once there's a list of the different infrastructures that are subject to right-of-ways, the tribe can say, what are our goals here? If it's an electric line is one of your goals to develop your renewable energy, well, maybe that right-of-way is an opportunity to help you be able to do that. Is your goal to improve your telecommunications and your internet access? Look to all the different right-of-ways you have for communications purposes. For the purposes of railroads, for example, if the tribes would like to use the rail for shipping, is there something that can be done with the right-of-way negotiations? Or if there's safety issues over a particular crossing or something on your rail line, is there something in those right-of-ways that can help you, or something that you can begin to renegotiate on those rights-of-ways? So every right-of-way then is an example of something that you can use to your advantage. The tribe needs to exercise jurisdiction over these rights-of-ways. So in the past, there have been some case laws that have said that if a tribal right-of-way is granted, the land rights went away from the tribe, and they were determined then to be with the utility or the other entity that acquired them, and it threw the jurisdiction of the right-of-ways into question. Because of course, if the tribe doesn't have the rights anymore, do they still have the right of jurisdiction? And the new regulations clarified this, saying that a right-of-way is a possessory interest, and it is not a transfer of all the real property or the jurisdiction. So the tribe retains jurisdiction over the lands within the rights-of-ways. So jurisdiction includes a lot of different things. It includes the right to regulate, it includes the right to tax, and it includes the right for you to basically require companies to stay in line with tribal law when they're acting on the reservation. So then that leads to the development and refinement of the relevant tribal laws. Once you know what your goals are, you can pass laws that make sure that they're applied. And I'll have another slide to talk more about tribal laws. And of course, tribal laws and development of tribal codes is another whole topic of conversation that is probably subject to a 10-day class, as opposed to a 1-hour little mention in a right-of-way discussion. So there's a lot more to be said about developing and refining your tribal laws. But the most important thing I can say is that tribes have tremendous flexibility to develop laws that work for them and that can meet their goals. So once you know what your goals are, you can pretty easily then put laws into place that exercise those goals. The next best practice is to know the land ownerships along the infrastructure routes. So know who your allottees are, know who the fee owners are within the same right-of-ways, because maybe they're your allies on making sure that a right-of-way is properly managed. And so you can easily be in communication with those folks if you have their information at hand. And of course, that's not always the easiest thing to do with multiple ownerships of allotments, but in some cases it can be a very effective tool in making sure that companies that are using Indian lands for right-of-ways are also in compliance with the right-of-way code for the benefit of the allottees and the fee owners that may be part of that route. And that leads to my next statement, which is tribal coordination with your allottees, and I'll add your fee owners as well. So making sure you have a communication line and that you have an ability to work with them in the event of a renewal of a right-of-way or any kind of issue on the right-of-way. The next best practice is to coordinate with other authorities, such as the BIA Realty. And it's not just BIA, it can be a number of other entities. For example, if you have a pipeline issue that has water quality issues, maybe there's another entity that manages your water quality. Make sure that air quality, you can talk to the EPA or others if there's an air quality issue regarding a matter. Or even like the National Transportation Safety Board, if there's a safety issue on a road or something like that. So there's all kinds of other authorities to coordinate with in addition to just the BIA Realty. The next step is to, again, gather and carefully review all those right-of-way documents and put your little spreadsheet together so you kind of know all the relevant information regarding those different ideas, and determine also, of course, whether the facilities are actually on the right-of-ways. There was a really good example at the Yakima Nation when they set out to put together a tribal utility. They went and gathered up all of the right-of-ways that were on the Yakima Nation, and they took their GIS handheld devices out and stood on the right-of-ways and documented where the right-of-ways were. And in many cases, they found that the facilities were actually 100 yards off of the right-of-way. And so that gave them leverage to go back then and talk to the utility company and make them renegotiate the right-of-ways, because the right-of-ways were technically abandoned because there was no facilities on the right-of-way, but they had facilities that were in trespass. So knowing exactly what's on the right-of-ways after you've gathered your documents and you know where they are, and adding those kinds of facilities into the actual GIS system that's owned by the tribe is very helpful. Another really interesting story I was told in the last year was regarding ongoing communications opportunities with right-of-ways. The Umatilla tribe had a big railway right-of-way that was coming up for renewal. And one of the things that the tribe did is they said, we want to put all of the information of the railroad into our GIS capabilities. And we want to develop and establish an ongoing communication on an annual basis, where in 1 year, the railroad executives come to the reservation and get a tour and talk about all the issues with the trains and the railroad. And then in the next year, then the tribal officials are invited to the railroad company's headquarters, where they get a tour of explaining how the trains are dispatched and all different kinds of things. The tribe insisted that it have all the GIS data on the rail issues. And they had a very good communication system then that was actually coordinated between the tribal GIS system and the railroad company's GIS system. And not a couple years after this was all put in place, there was a major derailment of a train at Umatilla. And within seconds, the tribe knew exactly where it was. The tribe could then give information back to the train company regarding any kinds of issues. They had tribal police on the scene within moments, and they averted huge environmental issues by their ability to have such a quick response. And while the railroad company was originally very concerned about all of this micromanagement, as they thought it was, after this event, the rail company went back to the tribe and says, we're going to use this as a model for all of our new rail easements and rights of way as they go forward, whether it be with any other community or any other state or any place, whether it's on Indian lands or not. So, you know, today's ability to have these amazing communication opportunities can be really beneficial, and it's a very different world than it was back in 1948 when somebody bought a right-of-way and then you never heard from them again. So let's now talk a little bit more about clarifying the tribal goals related to infrastructure. So see, these are some example goals that the tribe can list out. They can be very concerned, of course, everyone's concerned about safety and environmental protection. Of course, a goal is always compensation for your land rights, and these are mandated by law in the law and in the regulation. But you know, there could be other ways of having compensation. Ongoing communications, there's my Umatilla example. Ongoing income, is there an opportunity for taxation or other kinds of ongoing income? Can you obtain jobs or training with the utility company? Are there services that you need from that utility company? Does the tribe want partial or full ownership of the infrastructure? So you can do a preferred right to use interstate energy infrastructure, but for things like pipelines and transmission lines, that's not often supported by federal energy regulations, simply because those facilities have to be at a public and non-discriminatory access. And so no one can even give themselves a preferential right to use energy infrastructure. One of the current opportunities that was created by the Morongo tribe is that they had some major high voltage transmission lines that ran right in the front of their casino, and Southern California Edison wanted to upgrade or renew those rights, and Morongo established a company that they would become transmission owners, and they became partial transmission owners of those facilities. So there are opportunities. That doesn't necessarily mean Morongo or even Southern California Edison has a preferential right to use them. It just means that they have the right to operate them as part of a business enterprise in conjunction with the utility company. Another goal might be entrance or activity requirements on reservation lands. What do these companies have to do when they come on your lands to do maintenance or to trim trees or to do anything in particular? Do you have requirements that you would like to impose on them? And these include things like making sure that they're aware of historic preservation rules and any cultural mores that you have. Tribes, of course, have reserved rights on rights of ways. Sometimes the rights of ways, especially the old ones, aren't very clear about that, so you can clarify those. If you want to have agricultural uses of easements, or if you want to assure that hunting is permitted, maybe you want the company not to be doing maintenance out there during hunting season, for example. These are all kinds of things that you can negotiate or work out with the underlying owners of the easement. You can also have uses within the easement, such as parallel facilities that don't interfere with the easement rights. For example, if you want to build a communications facility in parallel with an existing facility, you can use their easement, but you may also need to have your own easement, but it can be on the same lands as long as it doesn't interfere with the other easement rights. For new easements, a tribe can negotiate much more flexibility about the actual facilities, the safety equipment and procedures, environmental mitigation, the design, the routing, and so forth. So just a little bit more about management of rights of ways. Again, the importance of that records inventory and analysis of existing rights, finding all the existing documents and GIS matching of them to the facilities. I always like to ask 5 questions about any contract that I'm reviewing. It's who, what, when, where, and how. Look at who. Okay, so one of the things that happens, especially on these old rights of ways, and especially in the oil and gas world, because these rights are bought and sold all the time, is that a right of way will be granted to company A, and then company A sells all their interest to company B. So then when it comes time to renew, you've got company C that comes to you and says, we want to review that right that company A bought. And you're saying, well, who are you? I've never even heard of you. You've never had your rights transferred onto my lands. So know when those rights are transferred, and make sure that if a company has a right of way on your lands, Google them and see if they're still in business, because especially for those oil and gas pipelines, oftentimes those old companies are gone and somebody new is in their place, and make sure that those rights were appropriately transferred under the BIA rules. The next is what? Are the rights limited? If you have a right to a 345 kV transmission line and all of a sudden there's a 500 kV transmission line there, those rights are not necessarily appropriate to what was actually acquired. When? Of course, we're all cognizant of the term of rights of ways. When was it in effect, and how long does the term go, and when do they expire? Where is the facility built in the right place? And how? What are the procedures for activities on the right of way? And these things can all be opened, reopened, and negotiated. For example, if you're having an issue with the particular right of way, There's nothing to stop a tribe from going back to the company and saying, hey, we know your term doesn't expire for another 10 years, but we'd like to negotiate some new terms about how you guys access the rights or whatever, to make sure that everybody's needs are satisfied in these documents. Know that state, county, and federal interests can hide facilities. For example, oftentimes the state highways have all of the utility and communications infrastructure on the state highway easements. And you have to look to state law, and you have to look to the actual highway rights of ways to determine whether they're broad enough to allow those facilities to exist. So you have to kind of do some legal research there to see if those facilities are appropriately permitted on Indian lands. When you're looking at any kind of a contract, including a right-of-way, it's a literal reading of the language in the document. So you have to actually read the words, and what do the words say? And they're the things that actually control. So the rules of construction of contracts apply. And so there are a bunch of laws that apply to construe contracts. In the case of federal right-of-way documents, you're going to look at federal law and you're going to look at tribal law. So that's an opportunity for the tribe's law to actually describe what needs to be, how those contracts are construed, whether they're liberally construed in favor of the tribe, for example, and et cetera. Again, what's really on the ground, assure that the tribe owns interest in allotments so that the right to condemn is not available. So if there's an allotment that has 50 owners and the tribe has even one part of that ownership, the right to condemn that along that allotment is no longer available. So when you have a lot of interests on an allotment and you want to protect it from being able to be condemned, make sure that at least some of the interest is owned by the tribe. Again, the tribe should exercise jurisdiction over the facilities and lands, and that can be done with a general section of their code, but it can also be done by drafting regulations and so forth that apply to the rights of ways. Kind of repeating some of this, here's the literal reading interpreted as a contract. What's the size of the right-of-way, the term, the conditions, rights of ingress and egress, any limitations on use, to whom was the right granted, is there a chain of title to any new owners? And then again, in any new documents, make sure and reserve the right to exercise dominion and control over the lands within the right-of-ways, including the right to tax, regulate, license, exercise civil conduct over activities, and the conduct of the right-of-way. Specify that the property remains in Indian land. This is currently in the new 25 CFR 169.10, but I would still add it in your section of your right-of-way documents so that the utility or other company knows about it. Limit your rights that are granted. Make sure that if it's, for example, an electric right-of-way, limit it as to voltage. If it's a pipeline, limit it as to the size. Say that they do not have the right to hang wires of others. If it's a wooden towers, say it's wooden and not the right to come in later and put up steel towers. Describe the access, the maintenance, the tree cutting, and any encroachments. And then describe the rights retained. What are the existing and future uses of the property? If the tribe wants to continue to use it for agriculture, if it's used for recreation, if the tribe is eventually going to build houses in the area, make sure that you describe the retained rights that the tribe has in those documents. Again, know the land ownership along the infrastructure route and have your tribal coordination with your allottees. Again, use your tribal GIS. And then, of course, coordinate your tribal strategy with your allottees. This is for existing right-of-ways as well as for new. It's helpful for the tribe to complete negotiations to set the price and terms before the utility acquires interest from the allottees for the same type of infrastructure. And consider also coordinating with any fee landowners on the route. So here's some example of the tribal laws that you may want to pass related to management of rights of ways. Local laws are often used to interpret the easements, make sure you're protecting your sovereignty. And then just here's a list of the code provisions. I'm kind of getting short on time, so I'm going to zip through this. If anybody wants copies of these slides, you can email me. My email's down there and I'll send these off. So here's some stuff about negotiating or renewing rights of ways. And this is a picture of a pipeline right of way here. So just to be clear, these right of ways do not only include oil and gas pipelines and electric transmission lines. These are for all kinds of facilities, for water, for sewer, for telecom. And I know with the recent broadband stuff, we're going to have a lot of new broadband right of way activity happening. So here's some of the best practices. First of all, know the applicable laws. For new facilities on tribal lands, tribes have the right to say no, unless Congress states otherwise. Congress can also always come in and say, we're going to build it whether you like it or not, tribe. But for the most part, the tribes have the right to say no if they don't want certain facilities on their lands. Pay attention to the facilities plan for the regional area that may affect tribal air quality or water quality, or fishing and hunting rights off the reservation, or even tribal first foods. Understand the right-of-way proposal, which is the application that the right-of-way applicant submits to the BIA and has to send to the tribe. Know its legal basis and what type of infrastructure they're talking about, whether it's new or existing. Contract with experts. There's a lot of great valuation folks out there that kind of can help you understand the value of your right-of-ways. Request tribal application fees to cover your cost to negotiate. One way to do this is to, once you get an application for a right-of-way, develop a temporary use permit, and as part of that, require an application fee. So for example, if a major transmission line is going to be negotiated, ask to have all of your valuation experts, your attorney experts, any other experts, have their costs covered by the applicant. And then you can also have the costs of your tribal negotiating team covered, because these matters should not come out of the tribe's other funds. The company that's seeking the right-of-way should pay a fee to the tribe, so the tribe can then hire appropriate people to get a good deal. Use new and appropriate valuation methods. Of course, in the past, the way the USPAP rules are, and USPAP is the appraisal entity that basically sets the standards for how appraisals are done. They do comparable sales. And so if it's an agricultural property on Indian land, they'll use an agricultural property off of Indian land. And that's not necessarily the best way to value that, because Indian land is not valued for its agricultural use. It's valued for its use as a homeland for Indian people and any other kind of other treaty matters. So make sure that you're using comparable sales, meaning comparable sales of other right-of-ways in Indian country. And there are companies that can do that for you and get you a much better and more appropriate valuation. Identify and provide guidance to a negotiating team, and the guidance can include making sure your negotiating team has confidentiality obligations, tribally coordinate with your allottees, negotiate those ongoing communications opportunities, and assure bonds and insurance requirements and obligations so that the companies are appropriately bonded and insured. So the federal laws that are applicable to right-of-ways include your treaty, specific statutory authority in various infrastructure laws, and I got some examples here. General federal authority, which is the 1948 Right-of-Way Act. So here's an example of reclamation law, which is infrastructure laws impacting land acquisitions and right-of-way negotiations. So if it's a transmission line or a dam, it was probably acquired through some of these Reclamation Act laws. So they have some specific applications that aren't going to apply to highways, for example. Treaties impact your right-of-way negotiation, and here's a couple of examples. Even though the Pick-Sloan Project Act, the Reclamation Act, allowed the condemnation of lands for federal dams, under the Fort Laramie Treaties of 1851, the South Dakota District Court found in 1958 that the Army Corps did not have the authority to condemn tribal lands subject to the treaties without specific congressional approval. So make sure that your treaties are considered when you're looking at these matters. Understand the proposal, the legal basis, and the infrastructure. Know what they intend to put on the ground, the ongoing maintenance needs, the schedule, the regulatory steps, and everything else. Know the legal basis for this facility, especially if the infrastructure is federal. Sometimes it requires specific federal authorization. Now, you've got to contract with your experts. Identify your negotiating team there at the tribe. You can include the allottees. Make sure they all have something signed with their confidentiality obligations. Request those application fees. Here's some more information on that. Here's some allottee best practices. The goal is for the tribe to negotiate excellent terms and conditions, which are then applied to all the allotments on the right-of-way. So include a process for allottee negotiations in your tribal right-of-way code. And when a tribe gets a rights-of-way proposal, send a letter to the applicant stating that they should not seek consents from the allottees on the route until the tribal negotiations are complete. Sometimes the allottees are offered a signing bonus, which gets them early consents in the door and kind of can mess up your tribal negotiations. Get a list, of course, of all your known allottees along the route and make a decision about whether the tribal right-of-way negotiations will include them or not. And if not, then assure that when an offer is made to the allottees, that the offer is consistent with the tribal terms. And then just keep a line of communication open. A little bit about appraisals. Here are some ways that have been done in the past. What is the cost to build around? What is the share of operating income? Those standard appraisals, the USPAP, comparable sales of generally non-Indian lands. But then the better one, which I got the little arrow here by, is trust land comparable sales. So comparable tribal land transaction. What other right-of-ways have been negotiated in the area? Consider the term, achieve a base annual land value, adjust for inflation, and have it paid annually or in a lump sum. This is kind of a little bit more about valuation. There's the communications opportunity I was talking about. So here's the other authorities you can talk to, EPA and other federal agency, other local governments. Here's just a kind of a paraphrase of the federal law. I'm not going to read you guys the law. You all can do that. And then here's the 25 CFR 169, the various subparts of it. And I've got a little bit about each of the subparts, but again, this isn't about reading you guys the code. You can certainly read the regulations for yourself. There's the federal BIA website regarding rights of ways. Here's about duration, renewals, amendments, assignments, and mortgages. What are the terms for amending a right-of-way or assigning them or getting a mortgage on them? And then the compliance and enforcement. So the BIA can actually take action to recover possession if somebody's in trespass, or if they're not using it or abandon it, or if they're not making their payments in time. So there's a lot of things you can do both at the tribe and at the BIA. So here's some other federal resources for BIA and one in Alaska. Kind of a different story in Alaska. That's another whole right-of-way discussion of its own. And now we've got a little bit of time for questions. I know I zipped through that last part, but if you guys want, I'll, like I say, ship you a copy of this presentation, or I think you can probably get it from Nichlas. So anyway, there, we can all go to the beach now because we're done, right?
Well, that would be nice. I know, I mean, here in Minnesota, looks like we're gonna get some pretty heaty temps coming in the next few days. So some actual beach time, something refreshing sounds great. Thank you very much, Margie. We do have a number of questions from people who would, I think have, some concerns or just some interest in rights of way. Yes, the presentation is scheduled on your calendars for 2 hours, and we'll probably go for another half an hour here, ish, to talking about different questions or some clarifications that you all might have. So if you're in the chat still, I encourage you to input questions or comments in the chat feature. And as I scroll down through them, we can explore those if we have the time to, or just depends on how things are going to be working out for us. Just so you know, yes, we'll make sure that everyone gets the slides. There's a lot of great information in there. A lot of people in chat really want those slides. We're going to get them to you. So absolutely, we'll make that happen. So the first question,
I'm trying to stop sharing and I can't figure out where to do it here.
Oh, let's see if I can.
If you can do it for me, Nichlas, that'd be great. There we are.
There we are. Yes. There we go. Okay. So one of the first questions we got was right after you started. If the new legislation will result in an increase in need for right-of-ways that the BIA mentioned, any increase in staff or technical assistance to process rights-of-way. So are there going to be any sort of increase in staff or technical assistance to process rights-of-ways if there's going to be this new legislation that comes in?
Well, I certainly don't know. If I knew the mind of BIA, boy, I'd be rich, right? Anyway, I would say that probably there's kind of been generally an increase of funding for a lot of different Indian functions. So I would hope that that would be something included. I know that for the U.S. Department of Energy and for BIA generally, a lot of their staffing is going to increase over the next couple of years due to a lot of opportunities for new grant programs and other programs. Whether or not those will be dedicated also to these right-of-way attempts is another question, but I would certainly hope so.
Hope so too. I mean, hopefully the next few years we'll have some increased funding to the BIA so that we could, the BIA could provide services more effectively and efficiently for our colleagues and our family across the country here. Let's see,
Can I add another thing that I think I kind of skipped over in the conversation here, and that is that tribes can 638 this process. The Hearth Act does not apply to right-of-ways, it applies only to leasing, but tribes also have the opportunity to 638 all of these activities on their lands. And so if a tribe doesn't like how the service is from their local BIA, I would recommend that as something to do as you're anticipating a lot of the infrastructure upgrades that are coming.
Okay, thank you. We have a really specific question here. Let's see. In 1888, U.S. Congress gave a railroad right-of-way. Does the Fond du Lac Reservation or original patents retain the land ownership under the right-of-way? And then can Fond du Lac tax the railroad for the right-of-way? So there's a two-part question.
That would require some specific legal review. And, generally what I'll say is if the right-of-way acquired a fee simple interest, then there's a little bit of a different issue than if the right-of-way is just a partial interest, meaning that they the tribe does own an underlying right. And so that would be actually included in the law, and it may be not clear. So oftentimes when it's not clear, the rule is that it's supposed to be interpreted in favor of the tribe and not in favor of the company. And so I think there are always legal issues like this that come up, and they're the kinds of things that that you can negotiate. I think even if it is something if it's within the reservation, and even if it is a fee simple interest owned by somebody else, the tribe still does retain many rights of regulation and many rights of taxation. I put together an article on utility rights and rules for tribal jurisdiction on reservations. It was published last November in the Energy Law Journal. So I can make that available to folks too. It's a really kind of esoteric legal description of utility rights on reservations. So if anybody's interested in that, just send me an email and I'll send you a PDF of that agreement. So it basically kind of gives you the legal overview of what you can and can't do on a reservation, depending on the types of land rights that are available.
Okay. And I know, Margie, you touched on some of the principles throughout your presentation on some of the questions that we might have coming up, but some of these are really good questions to hone in a little bit more, to distill your presentation into specific responses. But if Fond du Lac purchases land with an existing right-of-way, can the reservation then renegotiate terms?
I would think that you can certainly try. You can always approach somebody and say, hey, you've got a right-of-way. The tribe now has this land. The tribe, especially if the land is in trust, then you have much more leverage. And you can go to those folks and say, hey, you're now got a right-of-way that crosses over trust land. We want to sit down with you and figure out new rules and opportunities for us to work together. So it never hurts to knock on somebody's door and ask to renegotiate anything that you want to have renegotiated.
Okay, and then follow-up question was, to this piece is that the right-of-way was created before the Allotment Act. It only states Congress gave the railroad a right-of-way. So is the right-of-way an encumbrance and not ownership?
That's a legal question. I think you'd have to have it researched. Yeah.
That's the thing, in Indian country, we have so many issues that we're trying to look at and try to find solutions to. It's so legal and sometimes all over the place. And so it could be really challenging in that way. That's definitely the case whenever I look up something. I'm like, what's going on here? Why isn't this working the way I think it should work? Another question, something a little different. Can you share an example of a records inventory spreadsheet that you mentioned previously?
I don't have one that's public. I know I've worked with a lot of tribes that have developed those kinds of spreadsheets. I think, they would all be confidential unless I got some approval by a particular tribe to share it. But, if anybody wanted to email me, I could kind of give you some ideas of what what you want to put into that type of a spreadsheet. And it really depends on if you're focused on, electric or water or telecom or whatever. But those spreadsheets can be just really, really helpful in having, in one place, everything you need. And, a number of years ago, I was asked by a tribe that had, transmission lines all over their reservation. And they really didn't have a handle on when any of them expired or who owned which line, and they just didn't know. And so it was quite actually an effort to sit down at the BIA land office and first of all, gather all those right-of-ways. And in some cases, we had to go back to archives and have them delivered back to us. And in some cases, what the tribe had was not sufficient. There were supporting documents that were back in a file in Washington somewhere. So we had to gather up all that information, and then you fill out the spreadsheet, you know, with the terms, the conditions, who owns it, what is the chain of title for all the different assignments that have happened over the years, you know, and then any kind of a legal issue or any kind of an issue on the ground that's happening with those matters. So, you know, that can be somebody's full-time job if you're working for a tribal land office to start doing that. And it's just really helpful to start off with a really broad-based spreadsheet that has room to add a lot of comments in it, so that if you find something weird, you can add a little comment and say, wow, this is weird about this one, but I don't see it in the next one. And oftentimes if you have, for example, 5 different, if you have, for example, one pipeline and there's 5 different rights of way documents that cover it, they're not all going to be the same. And so to have that listed out and have some say, well, look, this one's going to expire next year and the other one's going to expire 2 years from now, you can basically go back and renegotiate the whole thing so it is all done at the same time, and so that the consistent terms and conditions apply. And that is especially the case is if with like Fond du Lac, you acquire lands after the fact that were actually, the original right-of-way was negotiated by somebody else, and now the tribe wants it and they want to bring everything up to consistency and up to whatever the tribal codes and tribal requirements might be for the time.
You know, I am a big fan of information sharing, you know, and so if, you know, if tribes are willing to share some information, I understand, you know, keeping some of that private, I completely get that. And, you know, that's a decision that tribes should make on their own, but it's certainly something that if we can share more information with other tribal nations across the country, we should do that. You know, we need to be able to work together on some of those pieces, I think, that could promote real practical sovereignty in some of these pieces. So thank you very much for that piece, Margie. We have a couple more questions here, several more questions actually. This is a hot topic, and looking at rights of ways that serve our community, not necessarily rights of ways that are just passing through. We have some dilemmas. Historically, there was never really rights of way allocated to many utility lines that serve the community, as we plan for a fiber optic line that will utilize previous poles and previous utility corridors, which never had rights of ways. Can old corridors such as these be considered grandfathered?
Well, one of the things that I skipped over, because I thought I was having to finish everything by noon here today, that I zipped through in here was the whole concept of service line agreements. And under the new right-of-way code, subsection B is all about service line agreements. And what those are is those are any kind of, it's a blanket agreement. For example, if the tribe is doing a new broadband company, and they're going to provide broadband specifically to their own membership and including their businesses and their tribal offices and their casino and everybody else. As long as those facilities are serving tribal entities, you can do one agreement that says the tribe hereby grants to this company, and it doesn't have to be a tribal company, it can be any company, a service line agreement for use of the service to the individual entities. So these are not useful for like your trunk lines and your large fiber lines that are, you know, bringing in the fiber, but they're for the individual service to the individual companies. And of course, you do have to have descriptions of where those distribution systems are going to be, but you can pretty much have one agreement for that. The other thing to keep in mind that's really important is that if it's the tribe itself doing this, the tribe doesn't have to acquire a right-of-way from itself. The tribe can, you know, there's probably going to have to be some kind of a tribal administrative rule as to, you know, you can't just go in and put facilities anywhere you want, you know, notwithstanding people's home sites and whatever. And of course, if you're going to go across an allotment, you have to have the rights. The tribe would have to have the rights to an allotment. But a tribe never has to acquire land rights for its own use. So I don't know if that's helpful.
Oh, I'm sure it is. I'm sure it's plenty helpful. You know, these are complicated tasks and complicated issues. So, your clarification is helpful.
So I guess the other thing I'd like to say about the grandfathering is that if the old rights of ways were acquired by Company A, and now the tribe wants to, for example, bring Company B in to provide service, Company A can assign those facilities to Company B. All right. So there's no grandfathering allowed, you know. Basically, again, you have to read the actual words in the agreement. So if Company A has the rights to, you know, certain land uses, Company B can't just jump in and use them. They have to be either transferred to Company B, or Company B has to acquire a new right. And it could be in the same place as Company A's, as long as it's not interfering with Company A's rights. Sorry, my smoke is getting to me.
Certainly. A few more questions for you then, Margie. If you could handle it, if it's not too bad for you right now. Okay. Can you speak a bit more about jurisdiction over rights of way? Did you mean that tribes taxing for the use or negotiating a reduction in taxes paid if covering fee land?
I guess I don't understand the taxes paid part. So I guess what I'm saying is that anything that's happening on the reservation, tribes have some opportunity and element of regulatory jurisdiction over them. And that includes also taxation. So tribes do have the right to tax activities on their reservation. And these rights can somewhat be altered by the ownership and by the agreements. For example, if it says right in the agreement that the tribe does not have the right to tax, then the tribe may have lost the right to tax because it agreed to that. But it really depends on going back and reading the actual words of the agreement and what tribes can and can't do. But for the most part, these things are silent and nobody says anything, which means that the tribes still have the right to tax or to regulate. For example, regulation could be making sure that the company submits information to the tribes on an annual basis, make sure that the company submits GIS information to the tribe as to where their facilities are, making sure that the company provides, you know, certain economic information to the tribes. You know, there's all kinds of regulatory requirements that you can impose, and including things like when you come on our lands, you have to give notice. Before you dig anything or before you cut a tree, you have to clear it with, you know, a certain office. You know, all kinds of regulatory matters can be handled at the tribal level.
Great. Some of the earlier legislation pre-1948 regarding rights of way referenced executive branch authority to adopt regulations. Are you familiar with many regulations that apply to these early rights of way?
Off the top of my head, no. I mean, the ones I'm most familiar with are all of the ones relating to reclamation law. So the ones relating to the federal dams and the ones relating to the transmission lines related there. There are US Department of Energy and Department of Interior regulations related to those matters. I think that I'm not as familiar with some of the old like railroad grants and other ones. So those would require your attorneys to go in and do a specific legal review of those. And I think anytime they want to do something new, then it's going to be those old laws will no longer apply. If they're expiring or something new is happening, then you have to start using the new regulations that have been put in place.
If a tribe granted a right-of-way to a utility and then wants to install its own utilities in that right-of-way, does a tribe only need to provide notice to the existing utility or also acquire right-of-way rights within the existing right-of-way, or does the existing right-of-way need to be modified?
Generally, you can't interfere with rights that have been granted. So if you granted a utility a right, then you can't make them move their facility or something if you want to supersede that. But if, for example, you want to hang a wire, say, for example, you have a distribution line right-of-way that's been granted, and you want to hang a telecommunications wire on those existing poles. You can't use somebody else's poles. You can't touch their equipment unless you get their approval. But as long as you can put your own poles up, as long as it doesn't interfere with the existing rights that are being used in the existing easement. And so the first thing to do is just to contact that utility and say, we want to put up, a fiber system, and we'd like to use your poles. So you can either then put together an agreement for doing that. And again, if it's the tribe using its own lands, the tribe doesn't have to acquire rights to use its own lands. It already has those rights. And so, but if it's a tribal, say for instance, the tribe has a Section 17 corporation, that Section 17 corporation still has the right to use the tribal facilities, or can kind of be grandfathered under the tribal rights if they have tribal approval and consent. And so the tribe can basically say to its own Section 17 or tribal company, we hereby give you the right to use tribal lands for the purposes A, B, and C, for your fiber, for any infrastructure related to the fiber, and as long as it's for service to tribal members. And then what you would do is say, okay, the tribe has now given our company the right to hang wires on the poles. Then you just have to get the approval from that utility. And the utility might say, no, our poles are really old and they're going to fall over if we add any more facilities to them, so we can't do that. But you're welcome to put up poles, within 20 feet of our poles. You're welcome to do that. And so you really then it's really just a matter of safety and security and making sure you're not interfering with the rights that somebody else already has.
So if a right-of-way expires and a different company wants to do a right-of-way, is this going to be a new right-of-way or renewal?
I would say it's probably a new right-of-way, because if company A is done with their right-of-way, that's an abandonment. And then a new right-of-way can be acquired in the same place. Or again, if it's the tribe acquiring it, they don't have to acquire their own lands. They can just begin to use it. And those things can be negotiated as well. What happens to the infrastructure on a right-of-way? That's something that's oftentimes left out of right-of-way agreements, is when you're done, do you have to dig up your pipeline and take it home? Or do you just leave it in the ground? And that's what those bonding and insurance requirements are for, to make sure there's money left at the end of the right-of-way to take care of any environmental issues or to remove facilities or whatever. You can also have the tribe can have the right of first refusal to take those facilities over if they want. But I would never say that a tribe must take them over, because then if there is an environmental hazard, you don't want the tribe to get stuck with that.
You mentioned that tribes can use the 638 to process rights of way. Do you know of any tribes using terras instead? And if so, has that been beneficial for them?
I think very few tribes have successfully done a Terra. I think a couple tribes have tried. I think they've changed the rules now to make it a little easier. Honestly, I still don't know of anybody that's done it because it's kind of as much trouble to do that as to go through the BIA process. And the real issue with Terras has been the NEPA issues, so that if the BIA isn't doing something, you don't have to comply with NEPA because there's no significant federal action that requires an environmental review. But if the tribe, but a Terra requires that the tribe have something similar in place, so they're still doing an environmental review. And so that has been a big problem, I think, with a lot of the tribes that initially wanted to do Terras. So no, that is a way to do it. I mean, technically that's a way on the books to do it, but I know of more examples of 638 than I do of, I don't know of any Terras that do that right now.
Okay. And can the tribe 638 individual trust easements as well as tribal trust lands?
638 is a process by which the tribes take over and contract with BIA to be able to do the BIA process at the tribal level, as opposed to having the BIA provide the land services. The tribe is now providing its own land service. So that's what the 638 process is. It's not a right-of-way by right-of-way or land right by land right situation. It's like who actually processes the right-of-way application and the valuation and all that stuff. The tribe can do that for itself if it acquires that contract from the BIA.
Okay. So in the case for Hoopa, the tribe is hiring a firm to construct a fiber optic line, and they are attaching to existing poles, for instance, power or telephone. But many times the BIA or their realty office does not have record of the right-of-way for the existing infrastructure. They have tried to utilize service line agreements for the service to tribal entities, but the BIA said they could not record it because there's no existing right-of-way to attach those service line agreements to. Do you have any advice?
It sounds to me like that's a mischaracterization of what the service line agreements are doing. The service line agreement is not something that attaches to an existing right-of-way. It's a separate agreement entirely. And so the issue there is that if you have facilities that don't have right-of-ways, then they're simply in trespass. And the tribe can pass a law to require them to acquire their rights of ways, and they can fine and penalize them for being in trespass. And then if the tribe actually wants to use, or the tribe's company or a company that is under contract to the tribe wants to hang poles and wires, they can certainly get a service line agreement to do that without, they're just going to have an agreement with that company. And I would assume that the company would make sure that they sorted out their right-of-ways before they gave the tribe the right to do it. So it's going to require, as in a lot of these tribal issues with a bunch of old facilities, it's rare that you're going to find right-of-ways all in perfect order. It's usually pretty big of a mess. And so it's a way to get the mess cleaned up, but the service line agreement is totally separate from an existing right-of-way.
You know, and one more piece, I think, just to close out our session here. It's just been such a good session, and you know, your slides are so full of information that's really important to how we do things and how we should be doing things now. You mentioned earlier on in the presentation that these are opportunities for sovereign expression, and it's true though that Congress could disagree and nix something that's in a right-of-way, correct? And so that in and of itself Leads
Well,
me to,
I guess, yeah, I will say no. Congress cannot abrogate an existing contract without paying just compensation.
just compensation.
So what Congress can do is abrogate a treaty. So, or Congress can basically take Indian land without Indian approval. But Congress cannot, and they can't do that without just compensation either. So if you have an existing agreement with somebody, Congress can't come in and abrogate that agreement unless they pay just compensation.
And in a new agreement, can Congress say, no, we don't want that in there, and therefore it won't be? Is that?
I don't understand. They don't want what?
So if Congress has a disagreement with a particular characteristic of a right-of-way that's being negotiated, could they maybe get rid of different provisions that may be included in there?
Sure. You know, Congress has a lot of power if it's federal land. And so, you know, and you can kind of even look at the Keystone XL pipeline there, you know, Congress could have come in and just granted an easement on any federal lands without regard to what the tribes wanted. But obviously they didn't do that. It would have been, you know, a political issue. And it would have been, you know, probably a morality issue as well. So, but anyway, Congress, if it's federal land, Congress has the right to do pretty much what it wants with it.
Right on.
Within the constraints of politics.
Sure, sure. And you know, part of the question that, you know, that came in for that is really just about, you know, to what extent, and it's more philosophical in some senses, you know, is to what extent, you know, are we exercising sovereignty in maybe this process or any process where Congress has any authority? I mean, if they can say no to something that a tribe wants to do, or if they can take from land that's they've taken from before, to what extent, you know, are we really able to express that sovereignty in meaningful ways? And of course, sometimes that's up to individual tribes to determine how that is to play out. So, you know, it's just something to think about, I think, as we continue in the work that we're doing and trying to plot ways forward. We are at time, so we do have a few more questions that came in. I will send them to Margie, and everyone should have her email address. It's been on the bottom of her presentation. The slides, you'll get a copy of that as well. The recording will probably be on the ILTF Vimeo account at the beginning of next week. So thank you very much, Margie, for your participation today. And as a reminder, we would like, you know, if you would like to participate in the Talking Shop session for tribal land staff on September 8th, you may go to the registration link. It was at the beginning of this chat box. Maybe we can get it there at the bottom here. Register for it. You'll get an email about that as well. But if you have more questions and you want to talk with other land staff about maybe how they've been able to achieve a goal, or what was their experience in this process, please do participate in that. So thank you all again, and we'll see you all next time.
Thank you. Everybody have a great day.